As I indicated previously, Your Honor, it's our position that the two sentences at the end of the principal instruction, specifically for second-degree murder, it is not necessary for the state to prove the defendant intended the death of Daniel Markell. For manslaughter, it is not necessary for the state to prove the defendant intended the death of Daniel Markell. As I indicated, it's a question of intent, and the principal instruction, the main portion, the defendant intended the crime to occur. I just think it's confusing. I understand the state's position, but under the circumstances, we would request that the court not give those two lessers.
Moment.
As I'm understanding, they're requesting just for count one simply to be guilty of first-degree murder or not guilty?
No. Mr. Evans to omit the lines pertaining to second-degree murder and manslaughter in the 3.5 sub A instruction.
Mr. Evans' understanding of our request is accurate. We're asking that the two lessers for count one not be given, and that would eliminate the necessity for those two sentences in the principal instruction.
What is the state's position?
You're talking at the moment, Judge. We're fine with doing away with the lessers on count one.
On this matter, I will need to take a call from the defendant. Ms. Adelson, please rise, raise your right hand to be sworn. Do you swear or affirm the testimony you're about to give will be the truth?
Yes, sir.
You can lower your hand. Ms. Adelson, you understand that lesser included crimes are something that is available depending on what is charged as a crime.
I understand that, correct.
Do you also understand as well, if you waive your ability for the jury to make this finding, they can only make a finding as to what is charged first-degree murder?
Yes, that's correct, Your Honor.
In consulting with your attorneys, you understand the strategy of waiving all lesser included crimes.
I do, Your Honor.
Is there anything that you need to consult with them further about concerning this matter?
No, there is, Your Honor.
Then you may be seated. As to the jury instructions, I will remove second-degree murder and manslaughter as options.
Given that, Your Honor, I believe moving the two principal instructions directly after count one would also be appropriate.
We'll remove any reference from second-degree murder and manslaughter in the principal instruction as well.
You get through that, Judge. I did have one side to change, I think, that I'd like you to consider. On principal instructions, the last line.
Give me one moment. Give me one moment. Right. Concerning the principal instructions, Mr. Evans.
Your Honor, the last line is both principal instructions where it says this instruction, currently says this instruction does not apply to count two. We would suggest that it be changed. This instruction applies only to count 1 and 3. It does not apply to count 2 in both areas.
Defense would concur.
Make the request to change. Let me repeat it once again, so this reflects what is requested. This instruction only applies to counts 1 and 3 and does not apply to count 2.
Yes, Your Honor.
Yes.
And given that principle applies to count 3, I'll withdraw the request to move principle after count 1. So it seems more, it would be more consistent with the fact that principle applies to count 3.
The positioning of the instructions will be after, it will be in introduction to homicide, count 1, count 2, count 3, principle 3.5 sub A, principles 3.5 sub B, intent, and then moving on to plea of not guilty, reasonable doubt, and burden of proof.
Yes, sir, and I see you have added 10, the language that was agreed to by both sides.
Yes. Right, as to the defense's request to move in certain portions of the 2023 and 2024 calendars under the rule of completeness, after reviewing this matter, the rule and cases associated with it last night, at this time, that is going to be denied, specifically as to the 2014 and 2023 calendars. These are not what the court would deem as a unified recording or writing. The calendars specifically are broken into separate documents by date. The 2014 calendar, any discussion of planning a party in no way connects with the license plate information that has been entered into evidence, which was done by a witness who authenticated that page, the handwriting, and other matters to reach the admissibility threshold, as that would go to hearsay without an exception or a witness testifying on the matter that will not be admitted. As to the 2023 calendar, these are not united by time or would otherwise lend context between the entries themselves. Again, if there is a witness who would testify to these matters, that would change the analysis. However, that has not occurred. As to those two items, they will be made court exhibits if necessary for any future review.
May I be heard on the 2014, Your Honor?
Go ahead.
One of the pages that the state included in, I believe it's 59A, the first page actually refers to the party. And in the state's demonstrative that was used through Sergeant Corbett, they actually highlighted that language. If I can approach...
Demonstrative, though, is not evidence.
No. In the presentation that they had with Corbett after the document was admitted into evidence, so the document itself is admitted, during his presentation, they highlighted language about the party. So I think that changed the analysis. If I can approach and grab the exhibit, Your Honor.
Please do.
Two calendar. One was the one with the tag number. I don't see that here, Your Honor.
May I ask you?
Exhibit 142, Your Honor. And the reference is on the Friday, June 13th. It's pretty much in the middle of the page.
As to this particular page, making any arguments as to what's been admitted is certainly permitted. How are the other separate pages, which are separate writings, in any way connected to this as completeness?
Your Honor, it's all about the birthday party. That using admission of that page alone creates a misleading impression.
Again, the court's ruling remains the same. For the item that has been admitted, you can make all arguments that can be reasonably inferred from this admitted item concerning the birthday party. Beyond that, the writings are not connected. This is not an issue of completeness as the court finds.
May we use the calendars as demonstratives during our closing?
You certainly may.
Thank you, Your Honor.
Are there any other issues that we need to raise at this time by either party?
The verdict form?
Oh, yes. The verdict form, Your Honor.
Yes.
Mr. Evans and I discussed on count 2 to conform to the indictment. We would ask that the count 2, we the jury find as follows as count 2 of the indictment: conspiracy to commit first-degree murder. And additionally, the conforming word in A.
Let me bring up the indictment. So you wish for it to read conspiracy to commit first-degree murder.
Yes, please.
As to the solicitation, do you wish for that to read the same as well?
Yes, Your Honor.
Any further issues concerning the jury instructions that need to be addressed?
Cover that. Your Honor, I just want to make sure you under subsection which says the defendant is guilty of conspiracy to commit, you did add first degree murder there.
The verdicts will read count one. We, the jury, find as follows as to count one of the indictment. First degree murder. The defendant is guilty of first degree murder. The defendant is not guilty as to count one. Count two. We, the jury, find as follows as to count two of the indictment. Conspiracy to commit first degree murder. The defendant is guilty of conspiracy to commit first degree murder. The defendant is not guilty as to count two. Count three. We, the jury, find as follows as to count three of the change that to indictment, not information. Count three of the indictment. The defendant is guilty of solicitation to commit first-degree murder. The defendant is not guilty as to count three.
Yes, sir.
Any further issues to raise concerning the jury instructions?
No, sir.
None on that, Your Honor.
Any other issues to raise?
I'd like to renew our motion for judgment of acquittal, same arguments, as well as all previous motions and objections.
Very well. As to the renewed motion for judgment of acquittal, the court has the same ruling in taking the evidence introduced throughout the trial in the light most favorable to the state. The state has met its burden to present all three counts to the jury. As to any review on this matter, the issue is preserved.
Thank you. And the last issue, Your Honor, we had discussions yesterday concerning a corrections officer at the Leon County Detention Center. We were able to get her served. Our investigator was able to, an investigator was able to track her down. Ms. Kessler, my paralegal, spoke with her afterwards. The information that she provided is our position that anything Officer Franklin would have to offer is not admissible, and that is why we did not seek to call her prior to arresting.
Well, parties can briefly approach. Before we bring the jurors in, we will have a brief break to allow the parties to get set any demonstratives and presentations that they will need for closing arguments. Please inform the jurors that we will bring them out about 9:25. Until then, the parties may do what they need to do to set up to get ready. I will print the copies of the instructions. If anyone needs to stretch their legs, use the bathroom, please do so. As to all observers for the closing arguments today, and this is very important, once again, you are not to make any gestures. You're not to make any facial movements. You're not to any way indicate to the jurors that you agree or disagree with what is being argued or what is being said. Phones need to be put away and placed on silent or turned off. Does anyone have any questions? Given what was brought up yesterday, that there was either murmuring or some sort of improper influencing or attempt to improperly influence the jury, that is not going to be permitted. You will be removed and also subject to contempt. Please raise your hands now if you have any questions. Otherwise, I expect you to conduct yourselves accordingly. We will resume at 9:25. The parties are to prepare for the closings at this point, or all presentations and demonstrations.